our societies need to be very conscious of human and people's rights as far as the application of criminal law is concerned. People shouldn't be criminalized, or their status shouldn't be criminalized. Poverty is not a crime. Poverty is a socioeconomic condition for which society itself should bear responsibility rather than criminalizing it. That is why it is so important that we indeed campaign for and ensure the implementation of these principles. And for that, the work of this commission, partner organizations, is so critical. And we do hope that states parties to the African Charter will take on the imperative for implementing these principles through legal reform, through public awareness, and indeed through socioeconomic measures for lifting the conditions of people in these situations so that they have a dignified life, as is deserved of any human being.
Today's convening comes on the heels of a very landmark advisory opinion rendered by the African Court on Human and People's Rights.
In December last year, the court rendered its advisory opinion, finding that quote-unquote vagrancy laws violated the African Charter on Human and People's Rights, as well as, very importantly, its protocol on the rights of women in Africa as concerns dignity, equality, and freedom from cruel and inhuman treatment. It went further to advise state parties to revise relevant parts of their criminal codes and procedures, as well as arrest and detention practices. And it's sort of to build on that victory and to take up that advice, or to help us organize to take up that advice that we're all meeting here today. Why does the victory matter? Because we know these legal provisions, procedures, and practices persist from colonial endeavors to divide and segregate us on the basis of class, gender, and race, to control our places of residence and our right to free movement, whether for life or for work.
So just to give people a little bit of background, the decision of the African Court relates to vagrancy laws and whether those vagrancy laws are in compliance with the rights in the African Charter on the Rights and Welfare of the Child, and the Maputo Protocol. Now, vagrancy laws are defined very loosely, and basically what the court looked at is how these laws are worded in both Anglophone and Francophone countries throughout Africa. So they have slightly different wording, but the one thing that is common in all these countries is that laws basically allow the criminalization of someone who does not have a means of subsistence, and it allows the police to also confront anyone who they think do not have a means of subsistence and to ask them to explain themselves. There's roughly about 2/3 of the countries in Africa who have these sort of vagrancy law provisions within either their penal codes or their bylaws. There are many offences from colonial penal codes that ought to be challenged. But the reason why we chose this one, because it's universal and because it speaks directly to an offence which actually says it's a crime to be poor.
So this brings in again issues of class, issues of discrimination, how arrests are then arbitrary based on these standards, and how access to urban spaces in cities and towns is becoming a mirage, or has been a mirage for vast swath of Africans.
All of these laws were rooted in very, very racist and white supremacist connotations. So urban spaces were separate spaces where Black people were not allowed to wander around or loiter or to ply any trade. Anyone found there without a reason that served the settlers would attract violent responses. So it's a shame that 60 years on, we're still at that place because nothing has changed.
When you look at these persons, these are very poor persons. These are very vulnerable persons. These are persons who didn't have much power.
If you're middle class, you do the same thing as someone who's poor, you're not going to face the same risks about being arrested and those sort of things. But the court also goes further. It says it's not just that you're being discriminated against based on your economic status. Some people are more likely to be affected by these laws because of the intersection of different statuses. And this is often the case with marginalized groups, where you're not just being discriminated against because you're poor, but because you're a sex worker or a child who lives on the street, or a refugee or a migrant or a person with a disability, or a range of other grounds. And it's this combination and intersection of vulnerabilities that makes the offences even worse, and that makes the impact and the way in which they're being policed even more arbitrary, and the police are more able to sort of exert their power over marginalized groups in society.
We have a big human rights violation going on in most of our countries. Although we call them petty offenses, they're petty offenses in terms of law, but they have major impact on the human being, on the poor, persons with disability, women, and children. And as such, the need for us as lawyers and judges and magistrates and advocates to ensure that such an issue becomes critical for the national agenda is vital.
Either our domestic courts or regional courts can find a significant potency in regional and international law that help affirm and protect rights in domestic jurisdiction. The provision is important in the current context, because it makes it difficult for Kenyan state or anyone else to fault the advisory of the African Court and its applicability in Kenya. Any person acting in public interest, and not just those of the affected by vagrancy and vagrants type laws, can seek relief, including the invalidation of the laws before the Kenyan court. And that there's been robust public interest litigation. And because of this, Kenyan courts would have jurisdiction that is anchored on the advisory opinion, and together with constitutional provisions on applicability of international law, use it to issue nationally enforceable orders and order compliance. And this is potentially a great tool that citizens can use, including by bringing to the attention of Parliament the existence of the advisory opinion and demanding that it repeals all offending laws or require the executive to provide steps being taken in that regard. I think that advisory opinion is already domesticated. So it's a question of implementation.
One of the things you've tried to highlight is how proactive courts, proactive lawyers, proactive litigants can achieve much based on their own constitution and also reliance on international law.
If we don't do much as activists to bring this to the knowledge of the government, of officials, of parliamentarians, of the courts of law, the judgment will remain, rather the opinion will simply remain that, an opinion which no one even may know about.
It's really important that we must celebrate good practices. We must celebrate, landmark judgment. We must celebrate whatever we see that is positive in this particular campaign. Okay, we need to continue to make sure that public is generally aware. Policymakers usually will respond when they think that whatever step you want them to take is something that is well accepted by the public.
Honestly, listening to everyone talk, everything seems to resonate. So I guess there are no boundaries in terms of how the criminal justice systems seem to have been doing or have evolved over the years. If you want to know what is wrong in your criminal justice system, you should step inside a prison and you'd probably find every bit of non-implementation.
This entire system of prosecuting low-level cases is about punishing the people for what are actually social policy failures.
These colonial institutions are so durable and they are so persistent. So across the Anglophone Caribbean is this preoccupation with the uncontrollable child who is unable to be regulated, just as our adult vagrancy laws are about uncontrollable adults who defy regulation. But the problem is that we strike down laws in a piecemeal fashion, but there's still very popular support for some of the underlying behavior. When I think about the decolonization project, I feel very much that colonialism has limited our imagination.
We just got 347 recommendations from member states around the world, and 263 of them were accepted by the US. So you guys, with this advisory opinion, have given us a tool for organizing. So I thank you.
Many speakers today have touched on the importance of this opinion for lawmakers and activists both in Africa and further afield, and the powerful tool it provides to tackle exclusion and discrimination across a wide range of marginalized groups. Listening to these experiences, I'm struck by the strong correlation between the kind of social and economic exclusion that we've been talking about and political exclusion, and how together they're contributing to a trend of authoritarianism we see across the globe today.
And this victory matters because this advisory opinion says all of that must change. So what do we need to do now? What we need now is thoughtful and timely action to realize the promise of this advisory opinion in all our states for all of our peoples. It was collective Pan-African action by all partners to the campaign present here that helped win us this victory, but it will take further action now, especially in country, to help realize the promise of this advisory opinion on behalf of the vast majority in all of our states.